be seated. Good morning.
Good morning.
The case up for oral argument this morning is Mr. Owens and others. This is a case that we've had more than once. We'll have it again today, and I think we'll probably have it again. Are you prepared to go forward, sir? You may approach.
Mr. Chief Justice, and may it please the court. The Circuit Court should be reversed for two independent reasons. First, the Circuit Court applied the wrong legal framework. Instead of looking to the original understanding of Article 1, Section 15's cruel, unusual, and corporal, the Circuit Court applied a novel legal test that requires a method of execution to cause a painless or instantaneous death to be constitutional. Second, the Circuit Court's consideration of the evidence cannot withstand scrutiny. As the parties challenging the constitutionality of a state statute, the respondents bore what this court has called the heavy burden to prove that law's unconstitutionality beyond a reasonable doubt. But the respondents' own experts, on direct examination no less, said things like the great question is what fraction of the current goes into the brain, but there is no evidence of what that fraction is. Or things like, I don't think it's possible to determine with any degree of medical certainty whether the inmates were sensate or not during application of the current. For parties with a heavy burden, these statements present an insurmountable hurdles to their claims. The Shield statute changes none of this substantive analysis. At most, that statute provides this court a jurisdictional off-ramp to avoid the constitutional questions presented here. Respondents no longer—
Do you think the Shield statute is properly before us?
Your Honor, the Shield statute was not pled in the complaint. It was not tried below. I don't believe the Shield statute is part of this appeal in the sense that it's being challenged directly. To the extent the court thinks the new Shield statute affects its analysis in this case, then I think the court absolutely can consider the impact of the Shield statute. But the Shield statute it isn't here on a facial challenge or even an as-applied challenge.
So what you're suggesting then that we should not address the constitutionality of the Shield statute, is that what I'm hearing?
Your Honor, I think if the court needs to address it to resolve the merits of the claims presented here, the court could do that. I don't know that the court has to necessarily reach out and address that question head on if it doesn't think it needs to resolve the constitutionality of the Shield statute to resolve the underlying questions that were presented here in the complaint and that were tried before the Circuit Court.
Well, you all spent quite a bit of time on that in your briefs, and maybe it is properly teed up, or are you suggesting that it's not?
Mr. Chief Justice, the Shield statute, we believe, affects the analysis here because it makes all three methods available. Respondents no longer face a choice between only the firing squad or electrocution. And whatever available means in Act 43, all three methods are certainly available because the department has said in Director Sterling's affidavit that it can use all three methods to carry out respondents' executions. So our opening blue brief spent only a page on the Shield statute and said you don't need to address this. At most, it's a jurisdictional off-ramp. Our reply brief dealt with it in more detail because the respondents raised and spent about 10 pages on the Shield statute in their red brief, which is what we were addressing. Fundamentally here, this is a case about the constitutionality of electrocution in the firing squad under Article 1, Section 15. That's the primary claim that's been briefed. It's the primary claim that was the focus at trial. And I think it's a question, first off, of what do those three terms mean? And the definition we have for those terms is the same today as it was when I stood here last January. A cruel punishment is one that superadds terror, pain, or disgrace, or seeks to intensify a death sentence. An unusual punishment is one that is contrary to immemorial or long usage. And corporal punishment is a separate category of punishment that affects the body but leaves the prisoner alive. So with those proper definitions—
Can a form of capital punishment become cruel over time? Evolving standards of decency.
So as an initial matter, Justice James, evolving standards of decency has never been the test this court has applied. In the 7 cases where this court has used that language, they're on page 13 of our blue brief, all 7 were discussing that test in the context of an 8th Amendment challenge.
Has the U.S. Supreme Court used that language?
It has used that language in 8th Amendment cases, Mr. Chief Justice, but the U.S. Supreme Court does not use evolving standards of decency in a methods of execution case. They use what's now called the Glossop test, It requires a condemned inmate to prove that there is an alternative and readily feasibly implemented method of execution that will significantly reduce a severe risk of substantial pain that the state has refused to adopt without a legitimate peniological interest. What that test recognizes is that capital punishment is constitutional. That's something this court has consistently held for decades. And if capital punishment is constitutional, there must be a constitutional means of carrying out that punishment. You cannot attack method by method where the state is left unable to carry out a lawfully imposed death sentence after trial and after appeal.
Well, in this particular case, lethal injection is not challenged. In fact, they have conceded that it is constitutional.
They have, and they have consistently said no less that the most humane way is lethal injection by a single dose of phenobarbital, which is now the department's protocol for lethal injection. So I think that's where I was going initially with your questions on the Shield statute, Mr. Chief Justice, but that's the jurisdictional off-ramp. They don't face the choice of electrocution of the firing squad anymore. Lethal injection is absolutely available, whatever definition the court would give to that term. So they haven't done it. Now, what I would recognize is this. These are 4 inmates in this particular case that have made this challenge. There are inmates across the country that are challenging lethal injection, including by a single dose of phenobarbital, as unconstitutionally cruel. The argument, such as in the Barr v. Lee case, tends to go, it creates the sensation for 15 to 20 seconds of drowning, and it's unconstitutionally cruel. And inmates who are facing lethal injection are proposing alternatives in federal court cases. So, for example, the Nance v. Ward case that the U.S. Supreme Court decided a couple of terms ago, the inmate's alternative method there is firing squad. And on remand from the U.S. Supreme Court, the 11th Circuit, in a decision by Judge William Pryor, said that the inmate could survive the 12b6 standard to pursue that claim against lethal injection with firing squad as his alternative. There are cases like that in Oklahoma. There are cases like that in Nevada. I go there, Mr. Chief Justice, to recognize that whatever these inmates have conceded about the lethal injection, there are inmates in other places that are challenging the very method they propose. So 2 points to that I think are important. One is the fact that other inmates are challenging the firing squad. They have experts talking about the firing squad being less painless, and courts are allowing those cases to proceed, suggests there's not the great difference and the obvious conclusion that lethal injection is less painful. The second point is this. There are more than just these 4 respondents on South Carolina's death row. I suspect the next one, who's not going to be bound by any sort of estoppel doctrine, is going to come into court and challenge lethal injection if that remains the state's sole method of execution. And this court's going to be facing that challenge under Article 1, Section 15, or the 8th Amendment down the road from now. There always seems to be a challenge to whatever method a particular inmate is facing, because that method always seems to be the worst. And the alternatives that inmate proposes tends to always be the method that someone else is challenging.
Well, let's address the grounds that Judge Newman used in declaring the electrocution method as well as the firing squad method is unconstitutional.
Certainly, Mr. Chief Justice. The Circuit Court made a couple of errors in its analysis. The first is that the Circuit Court required a method of execution to be painless or instantaneous to be constitutional. I am not aware of a single court across the country that has ever held such. And in fact, the United States Supreme Court, in talking about the prohibition on cruel and unusual punishments, has said that the Constitution does not guarantee a painless death, and that, as it put it in Bayes, pain is an inescapable consequence of death. The Circuit Court's second error was the burden shift it did. It effectively required the state to prove that these methods were painless and instantaneous. But in any civil case, the plaintiff bears the burden of proof. And this court has said time and again that when a party challenges the constitutionality of state law, that party bears a heavy burden to prove the law is unconstitutional beyond a reasonable doubt. So I want to take the methods one at a time, Mr. Chief Justice, so we can break it down and be precise. As for electrocution, respondents' experts said things like, there are no measurements to prove that the brain is rendered insensate in the early shocks. That's page 1169. The initial shock may or may not be rendering the brain insensate. That's 1186. The fundamental question is what fraction of the current is going through the skull, 1188. The great question is what fraction of the current goes into the brain, 1196. There is no evidence of what that fraction is, 1201. I don't believe that anyone today knows how long some period of time is before the inmate is insensate. That's 1229. And then this is Dr. Wixel at 1240. I'm not arguing for or against the idea that that electrocution is instantaneous. Now, Dr. Arden's testimony is even worse for the respondents. He said things like, I don't think there's any way to determine with any kind of scientific certainty this is happening first or that is happening first. He says, I don't think there's any way to predict, does the current immediately render you unconscious or not? That's 1327. He says, we really don't know how this affects people and whether it could render them unconscious or insensate rapidly or immediately or not. That's 1330. And then at 1330 later, he says, we simply don't know. The
Are you
critical
suggesting
question,
then that with those questions raised by the points that you've mentioned, defeats any claim of cruelty?
from the respondents, exactly, Mr. Chief Justice, it was their burden to prove that electrocution was a cruel, unusual, or corporal punishment. Their own experts, those are all statements from direct examination. No, that's not even the effective cross of Dr. Wixwood we have to reach to get those statements.
So
Your own-
you're saying that because of those maybes, let's just call it maybe testimony or I don't know testimony, that if that stands by itself, and even if Judge Newman did not find Wright, your expert, credible, then you're left with a tie.
We're not left with the time, Mr. Chief
Well,
Justice.
you're left with them not carrying their burden of proof.
Precisely. If the state had offered no experts, if Dr. Wright, Dr. Alvarez, and Dr. Dupree had never testified, and all the circuit court had were Arden and Wixwood's testimony, the respondents still would have failed to carry their burden on electrocution because their point was, we don't know. They said, if the inmate sensate, it's going to be painful. No one disputed that at trial. But that qualifier, if the inmate sensate, was the subject of great debate at trial and the subject on which their own experts could not offer a definitive answer or even an opinion with some reasonable degree of medical certainty.
And we
Mr.
went,
Lambert,
This-
I think we're going over a lot of ground we did a year ago. And you can take shots at the circuit court order, and justifiably so, for signing unedited, a draft order from the other side that's just a scorched earth order. She makes a finding there's no evidence that electrocution produces an instantaneous or painless death. Of course, there's plenty of evidence in the record. Now, she may find it credible or not credible, but to make those kind of statements that no evidence presented, the order just riddled with errors like that. But I wanted to ask you something more fundamental and see if you'll concede that the respondents are correct, that the state constitution provides greater protections because of the disjunctive nature of cruel or unusual, or if you even want to throw corporal in, as opposed to the Eighth Amendment.
I would concede that, Justice Kittredge, but I think it's important to be precise about what that greater protection is. Our Constitution, I want to focus again on cruel or unusual, uses the disjunctive rather than the conjunctive as the Eighth Amendment does. But what the respondents never show is that the words cruel or unusual in our Constitution somehow have a different meaning than they do in the Eighth Amendment context.
Well, I know we don't run to a modern day Webster's and say that's what they meant
Sure.
200 years ago. I think we all know that. But even using the original intended meaning, doesn't that add force to their argument? Particularly as it relates to the firing squad.
It adds force only to the extent the court has to do the cruel and unusual analysis separately. So on the firing squad particularly, I think that if I can perhaps predict where you're going into the unusual thing, because South Carolina hasn't used it before, 5 brief points on firing squad and unusual. 1, the firing squad has been consistently authorized in at least some American jurisdictions for more than 400 years. 2, states are beginning to add the firing squad as an approved method. So since I was here last, Idaho has become the 5th state to approve the firing squad as a method of execution. And it did so after it struggled to get lethal injection drugs and had to let an execution warrant expire in December of 22.
Has it
3,
conducted any executions by way of firing squad?
Your Honor, I don't believe so. I'm not aware that Idaho's
I
done
think
any execution.
Utah, has anyone other than Utah?
And since the lift of the moratorium on executions in the 1970, no, Mr. Chief Justice.
In the
Utah's
last
only
50
one.
years.
Sir,
In the last 50 years, only Utah has used the firing squad.
correct.
In the last 50 years, less than 1%, far, far less than 1% have been by firing squad. Since 1900, thousands of executions, far less than 1% have been by firing squad. And in the last 50 years, only Utah has exercised the method of the firing squad. And after the horrific episode that happened 2008, 2010, they haven't done it.
So I can't dispute any of that, but the end of it, I'm not sure what the horrific episode from
Well,
2010 was.
It's in the record, and we went over it.
We saw the pictures, and the pictures are bloody, but that doesn't mean that it was a horrific episode in the sense that the execution was somehow botched. I think my
Well,
last.
how about this? How about the fact that, and I think Justice Thomas, and it might have been the Bays case where he, in an opinion, sort of summarized the historical
Mhm.
understanding that we don't impose more than is necessary to accomplish death. Yet the very protocols issued by the director in South Carolina anticipates there will be a second volley of bullets. Doesn't that anticipate that there'll be the extended consciousness before death ensues?
No, Justice Kittredge. The protocol's written with redundancies because every protocol has redundancies. So the lethal injection protocol has the availability of a second and a third set of the execution drugs in case there is some issue. There's no indication that it would be necessary. And Professor Deno's work on the firing squad, I think, is instructive here. 144 civilian firing squad. She finds only 2 episodes of a botched execution. One, the inmate for some reason wasn't tied down and flinched. The second, going back, I think, into the 50s, the entire firing squad deliberately aimed at the abdomen rather than the heart, again, for reasons that aren't clear. I do think my last 3 reasons about the firing squad and unusual help address some of this, Justice Kittredge. The third one is that judges and justices across the country are suggesting the firing squad as a plausible alternative to lethal injection. Justice Sotomayor and Chief Judge Kaczynski of the Ninth Circuit are just 2 examples.
But
Fourth,
I
you have.
apologize for interrupting. Keep your train of thought. But aren't they focused on the concept of cruel? Because they're looking through the lens of the 8th Amendment that says cruel, and we have cruel or. So once they say, well, it's not cruel, they never reach the unusual prong.
That's a fair point, Justice Kittredge, but I think the fact that they're even suggesting this is an alternative that could be used would suggest it's not an unusual one, because it would seem peculiar to me for a Supreme Court justice to think, yeah, this is an unusual punishment, but since it's not cruel, we should start adopting this.
Well,
The fourth point,
oh, there's 4th, okay. I thought there was-
And a
I've
fifth.
actually got 5, Justice James, but
I'm eager to hear the other 2.
I'll get them real quickly. The fourth is something I mentioned earlier. These inmates are consistently proposing the firing squad as an alternative with expert reports. And the fifth, I think, is particularly useful. Less than 2 weeks ago, the U.S. Supreme Court allowed Alabama to proceed with a lethal gas execution. Before that, since the lift of moratoriums on executions in the 70s, there had been only 11 lethal gas executions in the country. Of course, there had been only 3 firing squads. 3 and 11 both pale in comparison to the number of executions that have been carried out by lethal injection or even electrocution during that time period. So if 11 doesn't seem to be a constitutional problem, at least in 8th Amendment context, I think that's some evidence that 3 shouldn't be one in this particular context.
It sounds like you want us to evolve as to firing squad not being unusual, but you don't want us to evolve as to cruelty.
We're not asking you to evolve at all, Justice James. The General Assembly has the prerogative to elect methods of execution. This court's held that going back to at least State v. Woomer.
They
back
have to
in
be
82.
constitutional.
Of course it has to be constitutional, Mr. Chief Justice. No one's ever suggested otherwise. But the firing squad has been a long-used method across American jurisdictions, maybe not as popular as others, but it's been consistently authorized, and people have used it because it's an effective method to bring about a swift death. So that protocol we were discussing earlier, Justice Kittredge, is designed to bring about a swift death. And yes, it is bloody. That's the result of a gunshot. But had the department designed a protocol that didn't involve the fragmentation bullets and cause the cavitation to destroy the heart so quickly and bring about that quick death, the inmates, I suspect, would be claiming a through and through shot's going to take too long to bleed out and leave them suffering for too long. And while we're on the subject of the firing squad, part of the circuit court's analysis there, I think, has a real problem. The circuit court's analysis on the firing squad said an inmate's going to be conscious for at least 10 seconds. The circuit court got that from Dr. Arden's testimony. Dr. Arden was the respondent's forensic pathologist who said that once the heart stops beating, oxygenated blood will remain in the brain for 15 seconds, during which time the inmate can be conscious. What Dr. Arden didn't account for and what the circuit court ignored was Dr. Alvarez, our cardiologist, testimony that made the fairly obvious point that if you are shot in the heart and the heart is ruptured, that closed circulatory system is no longer closed, and the blood rushes out of the body and the brain as gravity pulls it down. That's why Dr. Alvarez said that in his experience, when someone has a heart rupture, they're on the ground before you could grab the defibrillator paddles. So the at least 10 seconds isn't supported by the evidence. That's another flaw in the circuit court's analysis, where it doesn't make sense that you have the blood remaining. I think the pictures in the sealed volume, Justice Kittredge, that you referenced earlier, make it abundantly clear the blood's not remaining in the brain at that point. So the circuit court's at least 10 seconds is too long a period, even if the court were begin to think that there is some line drawing matter of seconds that could be constitutionally significant.
So cruel and unusual has a different application meaning than cruel or unusual here in South Carolina. So what does unusual mean in the context of the manner in which a death sentence cannot be carried out, and how, if at all, is the word unusual to be read in conjunction with the word cruel in our Constitution?
Certainly. So they are separate inquiries. I do at the same time think there is going to be some overlap in the analysis, because the historical understanding of unusual is this idea that it's contrary to long practice. So, for example, the Declaration of Independence in paragraph 6 criticizes King George for calling colonial legislatures together in places unusual, where they didn't typically meet. So it's this idea of something we've moved long away from. Now, I don't think that prohibits, and it cannot prohibit, the state from enacting a new method of execution we've never used before. Otherwise, lethal injection would have been unconstitutional in 1995, but no one's ever suggested as much. So I think what you have to look at in the unusual analysis is, was there a practice of using this, and did it become long disused, even if not wholly illegal or uncodified?
What about Justice Kittredge's reference? We're talking about the firing squad, the 50-year hiatus, if you will.
Well, I don't know it's a 50-year hiatus, Mr. Chief Justice. It's been used 3 times in 50 years. It was used 33 times over the course of the 20th century. It's not as popular as other methods. No one's ever contended that it was, but it's still been a consistently authorized and consistently used method of execution. South Carolina adopted.
Does it have something to do with not so much the statistical incidence of use, but rather the apparent acceptance of use by the states that are considering it?
Justice Few, I think that's a great way to think about it. And I think that goes exactly to what Justice Scalia said in his Glossop concurrence, when he said treating unusual as decline in use is, I think the exact quote was, akin to a white paper devoid of legal argument, that it's something more than just a numbers game. I think that's exactly right. And what you've had are the states that are using it, consistently using it and approving it. And yes,
So how would it ever become unusual if you subscribe to that position?
So
How can something ever be unusual?
That was exactly where I was going to go, Justice Few. Hanging was a method we used. We moved away from it in 1912 when we adopted electrocution, and we have never looked to go back to hanging despite having used it. Another example, and I think
Could the state legislature pass a law and reinstitute hanging?
Your Honor, I would have serious concerns that hanging would run afoul at least of the unusual prong, but probably also the cruel prong.
Wow.
It would be unusual, not only because of the statistical zero across the line in hanging, but because of the repulsive nature of it that has been recognized in law across the country over decades.
I think that's exactly right, Justice Few, and I think that's why it also has a cruel problem. One of the things we know about hanging, I think Stuart Banner's book on the death penalty in American history does a wonderful job of discussing this in great detail. Hanging was designed to result in a drop that breaks the neck, so it's an instant death. But we know from experience in watching hangings that often was not the case. That often it resulted in a drop that didn't break the neck and a death by asphyxiation, which resulted in minutes of struggle. So I think hanging is absolutely something that's not constitutional at this point, Justice Kittredge. The General Assembly couldn't go back and adopt it. Mr. Chief.
Now, what would be the basis for it being unconstitutional?
I think is my answer to the judges flanking you on either side, Mr. Chief Justice. It has an unusual problem because it's been rejected by courts over the last few decades.
But it was used over more than 100 years, now it's unusual.
Oh, I think so, because we've moved away from it. I think in this sense.
So now the evolving thing again.
But it's not let's be very precise about evolving, Mr. Chief Justice. If there is anything evolving, it's the people's consideration of these punishments and their decisions of what to enact through their elected representatives. It is not the decision of whatever particular court is hearing it. I think Justice Scalia, again, in Glossop, and the dissenting judge from the Mata case in Nebraska do a wonderful job of explaining how evolving standards of decency doesn't just open the door to
Does not merely open the door to subjectivity, it invites it.
exactly. That's the line, Justice James. So that's why it's not the evolving standards of decency from a judicial perspective. It's the debate that people want to have. And the people of South Carolina have clearly moved away from hanging. That's been 112 years now with no look to go back to it. So that's what's going to make it unusual.
Inhuman has the same meaning today as it did in 1895 for our Constitution or 1791 for the federal. Is that your position?
I haven't done the historical work on inhuman. I've done it on cruel and unusual. I think that means exactly the same thing, Justice Hill, those critical terms. If you look at our blue brief, it tracks this from about pages 16 to 23. We work through that history. When you look through my friend on the other side's brief from page 10 to 21 in their red brief, they talk about the amendments to our Constitution, how it's different than other states, different than the federal, but they never explain that cruel or unusual has a different meaning. So a couple of more points to that. One, this court in State v. Allen, a few years after Article 1, Section 15 was enacted, summarily dealt with the argument that the death penalty was unconstitutional under that provision, saying we did this 4 times under Article 1, Section 19 in the old Constitution. We know that answer. And also the West Committee, while it said it was modernizing the language and tightening the framework of what was there, the critical words, cruel, unusual, and corporal, did not change. And that indicates that there's no intent to change what those critical constitutional terms meant. South Carolina, in fact, enacted a prohibition on cruel punishments in 1790 in our first Constitution in Article 11, Section 4. Very different Article 11, Section 4 than we have now. But that's the same year South Carolina ratified the 8th Amendment, which prohibited cruel punishments. That's a strong indication that cruel has meant the same thing in our Constitution as it did in the federal. And I would note that both the Circuit Court and my friends on the other side, when they're trying to define these terms, look to U.S. Supreme Court case law to help unpack their meaning. There are a lot of other claims in this case. There's the statutory claim, there's my delegation.
Follow up a little bit on that idea of why hanging would have become an unusual method and yet firing squad did not. There has been a long period of time in which the use of the firing squad was rare. What is it about that fact, that progression or so in history that's different from hanging?
I think that the difference is the firing squad, while never is prevalent, has never been rejected by people in courts as a manner of execution to move away from. It's just been there, though not as frequently used. Hanging, there was an active movement away from it. Just as if you go back into some of the Supreme Court's cases, Bays, Glossop, Bucklew, particularly I think Justice Kittredge, you were noting Justice Thomas's opinions. There's a discussion of punishments in England that predate our Bill of Rights that England had moved away from over time, drawing and quartering, breaking on the wheel, where even if they hadn't been fully rejected everywhere by everyone, there was such a consensus move away from, they became unusual over time. I think that's what you've seen with hanging.
Does it have to do with the fact that there's a significant difference in the immediacy of death and the success rate of death, honestly, between hanging and firing squad?
I think that's a critical point. It may go more to the cruel question than the unusual question. I think the cruel question at its core is a focus on what does the condemned inmate feel? Is it super adding to his pain? I think we often get wrapped up in looking at what do the witnesses see? Oh, it looks bloody to them. Oh, that looked very clinical in lethal injection. But I think that misses the mark on what the analysis is. The real question is what's happening to the condemned inmate? What pain does he feel? But I think that is another significant difference between the firing squad and hanging, Justice Few. There are a lot of other claims here. I'm happy to discuss them if the court wants to. I get the sense the court is not full of questions on.
I have one more question. On this idea of the Shield Law and the efforts to obtain the drugs to carry out the lethal injection, what's the state's position on what information, if any, is available to a condemned inmate about the drugs that are about to be used to carry out the execution?
The condemned inmates know what the drug is and the dosage of it. The other information about
Well,
the drug
they're
is
told what the drug is and the dosage of it.
correct. Correct.
Are they entitled to know anything about the accuracy of what they're told?
Unless they can come in with a good faith basis and a plausible claim that they're being told something inaccurate, I don't think there's any claim they could present to say, well, we think the department's not telling us the truth.
Well, then how does the department itself know what the drugs are?
The department has experts who know, who are
Do they
pharmacists
test
who know
them?
what the drugs are.
They test them?
As far as I'm aware, testing is not part of the current protocol.
So, there's all this, these images that are being thrown out, about talking with people in shady alleys in third world countries about getting these drugs. And so at some point, the person who's selling the drug to the state of South Carolina represents what is being sold. Surely, we're not simply going to accept that representation as true. Surely, there's some method that the state would employ to verify that what is about to be used to carry out the death sentence is in fact the medication, the drug that is supposed to be used.
May I, Mr. Chief Justice?
Please.
Thank you. Justice Few, this court has never, since 1995, required the department to offer it some sort of proof as to the drugs are what they are. The department's charged with carrying out a lawfully imposed sentence. It's done that successfully at every lethal injection that's
I know, but
previously
the
done.
atmosphere has changed since 1995. There's a whole different
Very
world
much
out
so.
there in terms of the availability and reliability of the medications that you're getting. I simply want to know what, if anything, does the state do to verify that what they were told is the drug to carry out the death penalty is in fact the drug that should be used to carry out the death penalty?
As for the specifics of what the pharmacists at the Department of Correction do, Justice Few, I am not aware of that. What I can say on a couple of responses to that general line of thought is this. These examples of back alley driving schools in England or facilities overseas that have animals in them, the South Carolina Shield Statute in subsection J requires the state to comply with federal regulations regarding the importation of drugs. So all of that hysteria is nothing that should matter, because if the drugs were to be bought from overseas, they have to comply with federal law in bringing them into the country. And until there can be a plausible claim that an inmate needs to know this information and challenge it, the court should not embrace something that would allow, as Justice Alito called it, these seemingly endless proceedings. I would note one case, if I may, Mr. Chief Justice.
Well, I
There
know,
was an
I'm
11th
not necessarily, I'm thinking more in terms not of what, well, I started out with what are they entitled to know, but really, and then I turned to what does the state do to verify? And maybe it's enough that the purchase and importation of the drugs must comply with federal law.
I think it well might be. I would point the court to the Wellens case, which is on our gray brief at page 23. There, the 11th Circuit said specifically that an inmate was not likely to prevail on a claim about the dearth of information about the dearth of information about the nature of the pentobarbital that would be used in his execution. So I don't think these are claims courts have allowed to proceed. They're not claims this court should embrace.
Would you object to independent testing?
Yes, Mr. Chief Justice.
what
I think there's some challenges with that. One is you've got to find someone who is able and willing to test the drugs. Two, the minute you begin to test the drugs, you could alter the shelf life of the drugs, or you also, three, you have to move the drugs outside of SCDC's possession. And four, even with independent testing, whoever that tester is going to have their identity protected under the Shield statute. And I suspect that an anonymous test is never going to satisfy a condemned inmate as being sufficient to satisfy whatever concerns he purports to have.
You seem to suggest that compliance with federal law is sufficient. Yet the Bureau of Prisons has a protocol for lethal injection drugs, which allows testing and pretty much gives the prisoner all the information that Mr. Bloom is seeking in this case. So why not just adopt that?
That would be one option, assuming doing it was consistent with the Shield statute. That's a policy our General Assembly had the prerogative to enact.
It doesn't have anything to do with the Shield statute. It's about testing of the drug and the particulars of the drug and verification of its reliability and so forth.
If the department chose to do that and could do that consistent with the SHIELD statute, perhaps that would be an option. But the fact that the federal government doesn't mean South Carolina has to do it. And just to be very clear, my point earlier was that the state has to comply with federal law on the importation of drugs. I wasn't suggesting anything more in terms of federal policies on executions. But of course, if there's an applicable federal law, of course, the state's bound by it because of the supremacy clause.
To what degree of disclosure would the state agree with in disclosing information about this drug to the other side?
Your Honor, I think we have to be very careful about disclosing anything beyond what the drug is.
No identification information, but about the drug itself.
Your Honor, the minute you begin to disclose anything about the drug, you begin to give the other side puzzle pieces as to where the drug came from. So whether it's manufactured or compounded, what's the lot number of the drug or of the bulk materials, you begin to piece together who manufactured it, where could it have been compounded, who could have sold them the bulk material. And the minute you start releasing that, you make it harder for SCDC to get the drugs in the future. So while perhaps these respondents had the opportunity to choose lethal injection, people further down death row might not, because whoever supplied the drugs to SCDC this time might not be willing to in the future. I would point to Florida as an example of that. Florida used to use pentobarbital for executions. After having to disclose certain amounts of information, Florida couldn't get pentobarbital. It's moved to a 3-drug protocol now using, I think you pronounce it Etimidate. Well, now that protocol is being challenged. So I think the moment you begin to peel back the layers just bit by bit, you're going to chill the willingness of suppliers to provide the drugs to SCDC. And the General Assembly's goal of making it available, the department's work to make it available, this court's questions last time I was here in January of last year about why is it not available, all goes out the window because we gave too much away and how it became available. If there are no more questions, thank you, Mr. Chief Justice.
We'll hear again from you in reply. Mr. Bloom.
Mr. Chief Justice, may it please the court. And let me start with where you ended with that and go first to this question of disclosure. And the position, well, that they shouldn't have to tell anything unless we can come forward with a basis for why there might be a problem is itself a problem. Because how can you? If you know nothing other than the fact that it's pentobarbital, you have no basis to say anything about that. But the question of, yes, okay, there are questions that should be answered about this before someone is executed by lethal injection. The potency, the purity, and the stability are important questions about this. And if it's manufactured versus compounded, you have different sets of problems, right? If it's compounded, then nothing about the federal law is probably out the window because it was most likely compounded probably in state. So you have no sort of federal law sort of issue about that. But that raises the risk that it won't have sufficient potency, purity, or stability to do the job. And in many other states, they say, they provide, okay, we tested this, and this is pentobarbital. It's pure, it's stable. It doesn't have any other ingredients in it that might lead to something. And I don't think that them having to test it or have somebody test it and disclose that is an unreasonable burden before
When you say,
you go back.
when you say
bring out
disclose
a-
that,
Pardon me?
excuse me, when you say disclose that, do you mean the result of the test or what?
Yes, I think they should have, at a minimum, right, there should have to be a testing and a certificate of analysis. I mean, Texas does this all the time. For every execution, they provide a certificate of analysis. Somebody's gone in, they tested the pentobarbital, here are the results of the test. They provide information about the way it, that it was held at a proper temperature, because that can degrade the stability of it. And all of this can be done. None of this is identifying information.
How does this arise? So there's not a mechanism in the state law that requires them to make any kind of disclosure. You would, on the eve of execution, you would make some sort of request under the scenario that we're now talking about. They would either deny it or not fully comply with the request. You would file something with the court asking that the court require them to provide you with more information. Right? Am I right so far?
Well, I think probably the way it would, I mean, there are different ways you could do this, but one of which would be you set a date. The date is set, 4th Friday. The person has up to 14 days ahead of time to elect. I would assume the reasonable way to do it would be that the department have the obligation to provide that when the date is set before. the
Yeah, but
election.
that obligation, that's what I'm getting at. That obligation doesn't exist. You have to articulate a manner in which this dispute would arise, and then you get the relief that you're asking for.
Well, I mean, this court could order that happen. Or, I mean, the department could voluntarily agree to it. I mean, or you could go back, I mean, they suggested points, well, maybe they should go back and file another lawsuit on this. That seems to be.
Well, let's just assume that the court doesn't want to just write a requirement that doesn't exist under the statute, and the court wants to restrict itself to deciding cases and controversies, and the situation arises, like I was hypothesizing, that you asked for the information, you're not given it, you asked a circuit court or this court in its original jurisdiction for relief, and when you come in asking us for that relief, what would be the point of law that you would be relying on, that you would ask us to enforce when we are making the state disclose the information that you want?
I would think it would be arise from the fact that a person has a right not to have a cruel, corporal, or unusual punishment. And without this knowledge about this, it ups the risk of cruel, or not corporal or unusual, but it ups the risk of cruel. Another way to think of it would be as a minimum due process right, that you have an election that you have to make. You can't make an intelligent election under the code as it is without at least some minimal information.
It would go towards availability too.
Pardon me?
It may go towards availability at that
Well,
point in time.
that's true. I mean, another issue is, well, how much do they have it? How long will they have it for? That goes to available, and whether even you have to construe what available means, right? They have an unlimited supply going on, then I think under any definition of available, that's not a problem. If you have enough just for these 4 people and not after that, then you're going to be back here talking about what does available mean when the 5th person, or the 6th person about that. So I think you could do it either through Article 1, Section 15, or you could do it as a due process right. But the point is the person should have some basic information about this. And now, yes, we've been told it's pentobarbital, been told the dose that's going to be used in the protocol about that. They did provide the protocol, but that's it about that. And I think given, I'm not criticizing the director, but if you read his letter when he tells the court that they found it, it reads like he's going to say he couldn't get it. Because it goes on and on about all the things they did before they finally got it. So I just think given that, and it raises some of the questions that Justice Few said, there ought to be some, at least minimum disclosure of the purity, the potency, and the stability of these drugs that are going to be used to carry out the execution.
Has any other state refused to disclose this type of information?
Refuse to disclose it? Yeah, there's a wide array of what states disclose. I think Texas carries out the most lethal injections. They disclose this. The federal government did information like this when they carried out the executions during the Trump administration. So let me now go back to, I guess, the reason we were here a year or so ago on these 2 methods of execution. And I want to start with, I want to defend the circuit court a little bit on this. Some things. One, which way it cuts. She did not sign verbatim the order that was provided to her by counsel about that the circuit court made significant changes. But number 2, she also had to write this order without a transcript because of the time constraints that we were under that were set by this court. The order was written without the transcript. But even taking that into consideration, many of these findings are supported by the record about this and should be given deference about that. Electrocution, I'll start with that and then go to the firing squad. The court showed more. I'll talk more about that probably in this. But her findings on electrocution, they square up pretty close with the Nebraska Supreme Court's findings in Mata, where the court heard basically the same group of experts that it did in this case about this. And the notion that we didn't carry our burden of proof is, in our view, based on a misunderstanding of opposing counsel, sort of what the state of the record evidence is. Yes, it is true that Dr. Wixlow said, well, look, I can't say exactly what's going to happen in any one individual about this because experiments had never been done on humans. But he says, based on everything you know about electricity and what it's going to do when it enters the body, which is basically unpredictable, right?
But Mr. Bloom,
Well, let me back up and say it a different way. The fact that electrocution is going to be immediate and painless, it turns on one basic point. Is enough electricity going to enter the brain to render the person insensate and to induce the grand mal seizure? If the answer to that is yes, and it's going to keep them in this throughout the electrocution event, then it won't be immediate, but it will be painless. However, there are very good reasons to suspect and believe that there's a high risk that's not going to happen in a high percentage of cases. And why is that? That's because the skull is resistant to electricity, right? The premise is that it's going to go from the skull through the brain, out the chest cavity to the leg electrode and back 60 times a second. I mean, that's the premise. But the skull is resistant to electricity. The muscles of the face, the neck, and the side are not.
so the wet sponge does not,
Pardon me?
the sponge that's used, the wet
The
sponge,
sponge just increases. It doesn't control the direction of where it goes, of where it's going to go. And electricity, right? It, like many other forces in nature, what does it seek? The path of least resistance. So the electricity is going to go, what Dr. Wixell was saying, is going to go most likely in a significant number of it, is going to go around the skull, down the face, through the chest muscles and to the leg. And not enough is going to enter the brain in many cases to render the person insensate. Okay, why do we know that? Why do you know that? Well, one, you haven't tested it on humans about this. You can't for obvious reasons about this, but they have tested this extensively in the animal slaughter industry. And I'm not here to say, well, because you can't do this to a pig or cow, you can't do it to a human. That's not the point. The point is the animal industry has studied this. And when they use electricity to stun, they have one primary rule. You can't go head to hoof with the electrodes. And for exactly the reasons we've been talking about. There have been numerous documented studies that indicate if you do that, you don't necessarily induce the grand mal seizure and render the brain insensate. And that's why they don't do it. They use electricity to stun, but then they immediately kill the animal some other way, like they slit their throat generally, or use a captive bolt to do it.
Mr. Bloom, can I ask you to, you made reference to our standard of review, that is facts supported by evidence and record, findings of fact. Let's go through each one of these supposed grounds, or well, methods of execution, and I want you to find it in the record and the finding the fact for me and point to it.
I'm sorry, I missed it.
Finding of fact that will find, say, electrocution, since we're talking about that, cruel, unusual,
Where the circuit court made that? Those
yes,
findings?
yes.
Uh,
And what evidence in the record supports that?
What evidence in the record supports our findings?
Yes, so tell me what the finding is and what evidence in the record supports it.
Well, I think one of the critical findings here was because of the inherently unpredictable nature of electrocution and the occurrence of human error, an intolerably high percentage of the executions are going to cause extreme pain and suffering. That's Wixell's testimony if you take it as a whole in combination with Arden. It's not said by a witness in exactly that format. That's not what the expert witnesses are there to do.
So by that evidence being in the record, we ought to give it deference, is what you're suggesting.
Yes, and Dr. Wixell testified along the lines that I said. And her findings in this case are very match exactly what the Nebraska Supreme Court found in Mata and the Georgia Supreme Court found in Dawson. There's nothing idiosyncratic about it based on the evidence that was presented in this case.
So a different circuit judge on a different day, hearing the same witnesses, could easily have said, well, I believe right, and we'd be done.
Could say what? I'm
I
sorry.
believe the state's expert.
Dr. Wright.
And so we'd be done? Certainly
I'm
you
not,
wouldn't
I'm
have.
not suggesting it's blind deference. I'm just saying her
Well, I mean,
findings- Her
maybe that was the nature of the question, but that's what I hear you saying, that we are bound by what one circuit judge said about all this.
Well, it's entitled, there's a difference between being bound that you can't overcome and giving deference to the circuit court's findings. In this is an action at law. You're primarily reviewing for errors of law, but if the circuit court heard the testimony, I mean, it's not uncommon, right? A trial judge, or circuit judge hears the evidence. They make assessments of credibility and findings of fact, and appellate courts normally in general defer to those if there's evidence to support them. I mean, that's
We
pretty
say,
common.
we say that when we're talking about true, we do say that. We say it when we're talking about truly adjudicative facts, facts like were decided by the jury in these cases when the defendant was convicted of murder, facts in regular cases like what happened, when, where, who did what, and so forth. The facts that we're dealing with here are more universally true or not true, like you would think of as legislative facts. Does that make a difference? Because I mean, like Justice James was mentioning, what if a different circuit judge made a completely opposite factual finding? Well, if that were true, that would not, so somebody's got to be wrong on that one. I mean, and there is an objective level of truth of those facts that surpasses what any individual circuit judge would find in any individual case as to these questions, right?
Well, I think it depends as to some questions, yes, and some no. I mean, once she hears the testimony from this in competition and then makes some findings about what electricity is likely to do, I think that's a fact that was adjudicated at the hearing. She made a decision about it. But let me be absolutely clear about one thing. Deference or no deference. Her findings on this do have evidentiary support, and they are consistent with what the Georgia Supreme Court said in Dawson and what the Nebraska Supreme Court said in Mata, who are the other two courts which have resolved this in recent years, who heard challenges to this and found electrocution to be unconstitutional under the Georgia and the Nebraska Constitution under those circumstances.
We'll move to the firing squad.
Okay.
Let's go through the same thing.
Yes, no, I would, I'm happy to talk about the firing squad. The South Carolina Constitution, as you discussed, and it's, I think, in our view, clearly correct. It is not coextensive with the Eighth Amendment. It's worded differently, and it's worded differently in both, it's in the disjunctive, not the conjunctive, and it has a term that the other, the Eighth Amendment doesn't. It has corporal, neither cruel nor corporal nor unusual. And so unusual is, we're not saying the meaning of unusual has changed, just like we're not saying the meaning of cruel has changed. The meaning of cruel is the same now as it did before, but if you're thinking about it in terms of the electrocution, it's what we know about electrocution that's changed, and that means you have to reevaluate whether something's cruel. On the firing squad, it is for the reasons this court has said unusual. It's been used 3 times in the modern era, all by the state of Utah. It's been used 34 times since in the last century. 33 of those were by the state of Utah, which has its sort of own history of blood atonement linked to sort of the Mormon nature of the state. And it hasn't been used by any other state. So it's rarely used or been retired from use. I think that, but the other thing it is corporal. It's corporal. Corporal is not,
Define corporal.
Corporal basically is, the definition of corporal is that it mutilates the body.
Of or relating to the body, according to the circuit court.
Okay, of or relating, but I think normally we think of it in mutilation. That's how the court thought of it in Brown when you had the castration case.
So any state action that of and relates to the body would be unconstitutional because it would be corporal?
No, I think it's got to be a threshold. Lethal injection, for example, yes, it has to put a needle in the arm, but it's a minimally invasive procedure about this. It's not, I mean, if mutilation of the body, let's take that for corporal, which I think would be a reasonable definition of that. Firing squad mutilates the body. There's no question about that. Look at the pictures of Ronnie Gardner and what's going to happen here with the weapons that are selected. It's going to be more mutilation, I guess, than was present in Utah under those circumstances about this. So I think it's both, I mean, unusual and it's corporal under the South Carolina Constitution about that.
Is electrocution corporal too because of the damage done, pictures attest to by the,
I think
Electrode placement.
there's definitely a corporal component to electrocution, which we have argued in the brief and set out. The primary constitutional problem under our Constitution with the electric chair, in our view, is cruel, is that it's cruel. The primary problem with the firing squad is that it's corporal and unusual from our point of view, looking at this and looking at the terms of the South Carolina Constitution.
does it
Mr.
matter whether the corporal nature of the punishment occurs before or after death for our purposes?
Well, I think in both, it's happening during, with the firing squad, it happens before death. I mean, there's no question the person is there and they're shot and they're alive when they're shot, and that's when the mutilation happens. With the electric chair, some of it happens during the execution event. Some of it probably happens post-mortem. That the experts didn't quite agree on all this on where some of the burns were and where they were. And I think that's just, or they just were honest and said, look, sometimes you just can't tell whether something is pre-mortem.
Is there a distinction to be drawn on with respect to unusual? The number of states that have now adopted firing squad as a method, even though it hasn't actually been used? Are we to look at that evolution?
Well, I mean, in some ways with this, the proof's in the pudding, right? What are they actually using to kill people? In this, and it's still, since I was here last time, I guess it was 13 months ago, on this, every execution that took place by lethal injection, with the sole exception of the new method, which was used in Alabama, the one execution there, nitrous oxide. So other states, they're not electrocuting people, and they're not shooting people. But I think in some ways, right, even if they are, it's your job. I mean, this court decide, what are you going to tolerate in South Carolina? I mean, Article 1, Section 15, in many ways, is sort of counter majoritarian principle like the 8th Amendment. And this court is ultimately going to decide what are you going to say is a constitutional method of execution about that. And to the issue of, are these claims moot because now that they have lethal injection? I think the answer to that, at least in our view, is no. I think this court should decide whether the electric chair satisfies Article 1, Section 15, and you should decide whether the firing squad violates Article 1, Section 15. If nothing else, if so, somebody shouldn't be able to elect an unconstitutional method.
What about, the case, some of the cases that you've relied on, if I'm not mistaken, the Georgia case, the Nebraska case, those are electrocution cases where the statute does not give the inmate the choice that the South Carolina statute gives, right? Those cases are if the state dictates that electrocution is the method of execution, we find that violates the Constitution. Here, the state has pointed out that in some instances around the country, folks are taking the position that the firing squad, for example, might be a preferred method of execution over lethal injection. And one way of looking at the South Carolina statute is to say, well, first of all, killing a man doesn't matter the context, but even the lawful killing of a man by the state is a gruesome endeavor. It's going to be an awful procedure. And there are issues with firing squad, electric chair, even lethal injection. So let's enact a statutory scheme that once this condemned man faces the eventual prospect of execution, the condemned man gets to choose his preferred method. A terrible choice to make, no doubt. But given the fact that there are horrible aspects of the carrying out of any one of these methods of execution, why does the fact that the South Carolina statutory scheme gives this choice actually significantly distinguish it from the Georgia case, the Nebraska case, and others that have looked at the methods in isolation?
Well, I think I have actually several responses to that. So let me see if I can get it in an articulate manner. One of which is none of those states had a corporal provision in their constitution about that. So the South Carolina Constitution is different, and I think that leads to a different way of thinking about it. Secondly, someone, and obviously you're going to decide whether you agree or disagree with me about this, but I don't think somebody should be able to elect an unconstitutional method about that, and they should have, you don't have a constitutional right.
But that's like the state says, okay, you're condemned to die. How do you want to die? I'd rather die by the firing squad. Nope, sorry. The state has to step in and say, you can't choose the firing squad. That's unconstitutional. The defendant made the choice. That's my point. The defendant gets to make the choice. You have argued, and you've done a good job of putting this spin on it, like giving someone an unconstitutional choice is a violation itself of the Constitution, when in fact, all three of them can be argued to be unconstitutional in different ways. We're just letting the defendant choose.
And so another problem with that is, look, if you leave all these methods in place, will somebody pick the electric chair? Yeah, somebody probably will at some point. And we know from history that 3 people have done it in South Carolina since you had that. And the one thing all 3 of these people had in common is they were severely mentally ill. Larry, Gene Bell, Tucker, and Reed. And there were real questions about their comps to be executed. Another problem with the way the statute is currently written is probably the most cruel method is the default method under the South's worded. So an inmate who couldn't choose or wouldn't choose and have the ability to choose is going to be elected.
But I mean, so an inmate who couldn't choose, that would be because they were not competent. And if
Yes,
that's accurate, then they can't be executed.
They might not, well, I mean, you could be not I mean, that gets complicated. What's the competency standard? There's a different standard for competency to be executed. And maybe they might not be competent to choose and might be competent to execute, know what they're going to die. Maybe they would be paralyzed or immobile about this and not able to do it. Or some people are just going to choose it. But again, it just goes to the point. This is, it's a heavy burden. You wouldn't want to have it if I were in your shoes, but I think you do decide whether these methods are constitutional or not, and what somebody's going to be allowed to pick. I mean,
What if you're just left with lethal injection? What's your argument on that?
Then there's not a problem. I mean, the lethal injection, there's not been a single successful challenge to lethal injection anywhere. The Supreme Court of the United States has said that a single dose of pentobarbital satisfies the Constitution in Barr versus Lee, and there is no constitutional right to choose. Here, it's a state statutory right to choose. So if the legislature, for example, enacted, or if this court struck down the other 2, and there was just one, there is no constitutional problem.
What if we said electrocution and firing squad are out? Would you have a quarrel statutorily or constitutionally about lethal injection being the only method left in South Carolina?
No. No, I mean,
You just go.
that's
with-
how it works in many states. I mean, there's
You-
just lethal
but you-
injection.
But you would quarrel with the availability of lethal injection. That's what you argue in your brief, right? It's not available, or it's void for vagueness.
Well, it's currently available. I mean, under any definition, under the definitions that we share, right, it's currently available. They have it. The statute is not clear on this. I do think the court's order the last time indicates that it has to mean that the director has some affirmative duty. You're sitting back, indicates that there's some affirmative duty on the part of the director to make at least currently all 3 methods currently or lethal injection available under this.
At the time of the election.
Pardon me?
At the time
At
of
the time
the
of the election,
election.
yes.
Let's talk about the time of the election. Justice James referenced whether or not you had some problem with there being only one constitutional method available. Yet the statute allows an election. Would that create a problem?
No, there
I'm just trying to get you.
there is not a constitutional right to election.
Well, it's statutorily. Let's talk about that.
Yes, the statute currently does give.
But if these other 2 are declared
2 are
unconstitutional, you only have the one that you do not object to, the lethal injection, would there be a problem?
I don't think there would be. I mean, could this court sever that? I mean, actually, I'm not sure I'm smart enough to figure that part out. Could you sever it and do it? Or would the General Assembly have to fix it and do it? If they did that, I mean, they proved with the Shield Law, they could fix this thing in a nanosecond about that, just like they passed the Shield Law. So, but one of those two options. But if you were left with a single method of execution, which was lethal injection, there is no constitutional problem with that under
All
the
right,
state.
now we got that one out of the way. Let's talk about the Shield statute.
Okay.
Do you have, or what are your objections to the Shield statute? Constitutionality.
We are not here challenging the constitutionality of the Shield statute. Our position is that the individuals are entitled to some information about the drugs, like we talked about at the beginning. I don't see how any of that is prevented by the Shield statute, which goes to identifying information. That's all that it talks about. Our position is that if their position is right, because let's face it, their position is pretty stark. They don't have to tell anybody anything.
Would that make the statute
I
unconstitutional?
think that would. If you don't have to tell because their position is now they have to tell us, they don't have to tell the inmate, they don't have to tell you, they don't have to tell any court anything about this. And their position, I think, would be the same, is if they go out and execute this first person with these lethal injection drugs and it goes horribly wrong, it's a severe botch, their position would still be, we still don't have to tell anybody. And that just can't be.
Well, this is why I asked you in the beginning, what's the provision of law that you rely on for this as a source of this information?
I think it's either a due process right attached to the election, or it would flow, I think, naturally from the person has the right not to have a cruel execution. And so this basic information is part of that process about that. I think you could go through the due process clause or through Article 1, Section 50.
You say basic information. It seems to me they don't want to give you anything. It seems to me, even though you probably won't acknowledge it, you want everything, at least enough that you can stir the pot and deter folks, companies, individuals from providing the drug to the state. Help us with a framework that would be somewhere in between, that would give sufficient information to determine the quality of the drug, its useful life, whether any quality control measures were undertaken by the compounder or the manufacturer. Where is an amount of information that would comport with due process, yet not transcend the intent behind the Shield Law?
So first, I'm going to answer your question directly. I'm going to quibble a smidge with the premise of this. I'm not here today on behalf of drug manufacturers or pharmaceutical companies or any of that. I'm here on behalf of 4 people who, most of which are probably going to be executed about this. And I'm here on behalf, I think, of their interest to make sure that it is as humane as possible, when the state carries out the punishment of death in their cases. And I don't have any interest in finding out who the manufacturer was or who the compounder was. I mean,
Fair enough.
About that.
But help us, you're both sides well represented, so well prepared, and I'm sure I speak for everyone commending both sides. But help us understand where you think the appropriate line should be drawn that would satisfy due process and nevertheless comply with the Shield Law.
I think the minimum, the absolute minimum that would do this is to provide documentation, like in Texas, the federal government, of the quality control and the testing for potency, purity, and stability. And that's what's going to determine. I mean, what you want to know is, right, are the drugs going to do the job? And are they going to do the job without some horrible event like Clayton Lockett where they couldn't kill him, or if it's not potent enough, it might even kill the person. It might just render them brain dead. And I don't see, none of that is barred by the statute. that I don't see and would do it. I mean, whether it's compounded or manufactured is relevant to that, I think, in some ways. But if it's manufactured, right, it is what it says it is, because that, there's a lot of federal law on that, about that. If it's compounded, that creates a whole set of other problems. But I think we're talking about potency, purity, and stability, and proof of testing that it's bad, so the person knows, okay, it's going to do the job.
I'm going to give you an additional 2 or 3 minutes to talk about ex post facto and the other bases that you raised. But let's get back to the framework we're talking about here. You make a distinction between compounding and manufacturing, and we all understand there is a difference. But if you were to give us some guidance, if you will, as to what would be appropriate in asking for that information.
Well, I'm not going to sit here and say that I have no idea, what they got and where they got it from. The difference is, I think with compounding, it just heightens the need for some type of testing to determine potency, purity, and stability, of this.
So you're suggesting independent testing, or testing by them with the results
I
given
think
to you?
There's also a public transparency issue in all this. Is the public going to know this? And I think an independent tester could be, that's not going to reveal who made this. They do this, lots of places. It didn't reveal who the federal government got it from. And the general consensus is Texas compounds it, themselves. But I don't see how that reveals who it was.
Okay. You got a couple of minutes to address your other ground.
I think, I don't know that I need to prolong this. I think that on the ex post facto part, I think if this is in fact pentobarbital that will do the job, then we don't have an ex post facto claim anymore. It was contingent upon the other two methods being worse than. We conceded lethal injection is the most humane way. So I think, aside from any issue of these drugs, if that's what it is, there is no ex post facto.
I have a quick question. I know this is a declaratory judgment action and the standing requirements are somewhat relaxed, but how is this case ripe if an election hasn't been made by your clients as to which method of execution they want?
How is which part right? The entire thing?
Yes, if the choice you don't make, that we can rule that they're unconstitutional when that choice hadn't been made yet.
Well, I think it was primarily a facial challenge, which the people would have the right to do it. But I think maybe I don't understand. I'm not sophisticated enough on standing on this, but I would think these people have standing to say, we need somebody to declare which of these methods are constitutional or not, so we can make the choice. All these people were facing imminent execution at the time this lawsuit was filed. They had completed the ordinary course of appeals, and the only thing left was to wait for this court to set a date. And I think that made it right.
Well, part of the problem is that the choice expires. If the inmate makes a choice, if the convict, so the choice is made, say, lethal injection. Subsection A, if the convicted person receives a stay of execution or the execution date has passed for any reason, then the election expires and must be renewed in writing 14 days before a new execution date. So you could easily have someone choose firing squad. Hypothetically, the court declares it to be constitutional. And then when the new execution notice is issued, the same person chooses lethal injection.
Yes, but I don't think that has anything to do with the rightness of it.
Well,
if not, you could never get it done.
Right. That's what I think it has to do with it. Is it
capable of repetition,
we would have to
debating review.
That kind of is to mootness, but in terms of ripeness, the case is only ripe Judge Hill raises a very good question. It's very much related to my question about the significance of choice within the statute. But
they had already made a choice and it expired, right?
They'd chosen lethal injection. Yes,
Right.
all four chosen lethal injection. But I think it's sort of similar to the federal concept of capable of repetition but evading review. That there has to be some mechanism to do it, or you're constantly, okay, every time you got to file a new lawsuit. But I think, I don't see any point in having another lawsuit about this in the Shield statute. The issue's been briefed there before the court, and we would encourage you to rule. Thank you.
Thank you very much. In reply, sir.
Mr. Chief Justice, and may it please the court, 3 primary points in reply, and I'd like to start with electrocution and what the evidence in the record says. Whatever else there may be, Dr. Wixwo said there is no evidence of what the fraction is of the current going into the skull. In his declaration, his affidavit filed with the complaint, the draft said the vast majority doesn't enter the skull. And in Dr. Wixwo's comments back to my friends on the other side as they were drafting it, discovery revealed that he actually left a comment saying, what do we have to prove vast? It's page 1263 of the record. He tried to prove what the fraction was, and the leading peer-reviewed journal in his field rejected his paper. That's page 1269. As for Dr. Arden, he testified specifically, and I want to read it so I get it exactly right. I don't think it's possible to determine with any kind of medical certainty whether those people were sensate during application of the current or not. Testimony like that in the mind run of cases involving an expert would summarily defeat the claim. There is no reason to treat this case any differently when that's the expert testimony. As to the burn.
In fairness to Mr. Bloom, in the circuit court, wasn't there testimony about the difficulty because of the thickness of the skull, the nature of it, that the theoretical construct of how this is to operate that we've learned over time is not necessarily how it plays out in real life?
Well, there was testimony, Justice Kittredge, that the skull is more resistant than other parts of the body. And Dr. Wixwo said that, Dr. Wright disagreed with it, but focusing just on Dr. Wixwo and where he falls short. He also talks about the 2 electrode therapy where it's put on either side of the head. If electricity can't enter the skull, that type of therapy would be completely pointless, but yet it's regularly done on people today. As for the...
I'm not saying there's not evidence to support your side.
Oh, I appreciate that, Justice Kittredge. I just want to focus on... Go ahead, I'm sorry.
No, I didn't mean to interrupt you.
No, I just want to point out the flaws in Dr. Wixwo's own testimony. While he's saying, yes, the skull's more resistant, he can't begin to describe what the fraction is of current entering the brain. So when you're looking at the first phase, which is 4.5 seconds at 2000 volts, it could be a lower percentage, but that's still a lot of volts getting through in an absolute number.
So there is evidence to support their questioning about this being immediately rendered unconscious. And you're shaking your head.
I'm sorry, I don't want to jump too quick, Justice Kittredge, please.
But I understand your position is speculation. And when we get down to speculation, we look at who has the burden of proof.
Precisely, that's it. So, I mean, for example, as they talk about the burning in electrocution, Justice Hill, both Dr. Arden and Dr. Wixwo said, I cannot look at a burn in an autopsy and tell is that pre or post-mortem. Wixwo says that at 12:15, Arden at 13:72. So their own experts have said, yes, they're burns. We have no idea if that came before or after they were sensate. The only pre-mortem wound that Dr. Arden could say definitively happened in electrocution before the inmate was dead was bruising around the wrist. But that would certainly seem to be de minimis, even by my friends on the other side standard, if the bruising from an IV being inserted to your arm is. Finally, on the subject of electrocution, the respondents rely heavily on Mata and Dawson from Nebraska and Georgia. 5, again, Justice James, quick points on that. 1, those courts use evolving standards of decency. 2, that ignores that in the same time period, Florida in the Jones case upheld the constitutionality of electrocution. 3, those cases were decided at a time when lethal injection drugs were widely and readily available. 4, those cases were decided at a time where everyone assumed lethal injection was less painful. That is, in fact, not the case anymore, given the overwhelming volume of lawsuits we're seeing in federal court. And 5th, the logic of those decisions says there can only be one constitutional method of execution. But when you're looking at cruel and unusual, the United States Supreme Court in Bucklew specifically rejected the idea that traditional methods of execution, citing both the firing squad and electrocution, become unconstitutional because of new methods develop.
Well, the Georgia case is interesting because the Georgia Constitution had been amended to remove electrocution as the default method of, or available method of imposing the death penalty. That gave their Supreme Court pretty clear signal, and they said this, that go ahead.
Correct. I think that's a 6th point. So now I'm up to 2 hands and counting.
I wasn't going to number it for you.
No, I think that's 6. Quickly, as to the firing squad, my friend on the other side focused on Corporal with that. I am not aware that this court has ever applied the prohibition on corporal punishments to a method of execution, but South Carolina's had that prohibition on such punishments going back to the 1868 Constitution.
Have we ever
It-
been asked to?
The court has never decided the question. I'm not sure what might have come up at briefing and argument in any case going back over the last 160 years, Mr. Chief Justice. But long-standing legal doctrines treat corporal and capital punishments as distinct. Blackstone in Volume 4 of his commentaries does it. The North Carolina Supreme Court in a Lumberton case, it's at page 23 of our blue brief, says that someone who thought corporal and capital punishments was the same in writing a statute was totally ignorant of the technical meaning of the term. That's the North Carolina Supreme Court saying that. Finally, I'm not aware of any court that's ever held the firing squad to be an unconstitutional method of punishment. Finally, I want to end with this boards of inquiry idea and what the Shield statute would require or even permit the department to disclose. The U.S. Supreme Court in Bays, when it began this consideration of method of execution challenges, warned courts not to become boards of inquiry embroiled in scientific controversies beyond their expertise, essentially trying to quibble over, is this slightly less painful than that, or is there some significant amount of difference there? If the court's going to require the department to disclose anything, the court needs to think carefully about what's disclosed, how it's disclosed, and to whom it's disclosed. Because if too much is disclosed or it's disclosed in the wrong way, it will thwart the efforts of SCDC moving forward to obtain the drugs, and lethal injection will once again in South Carolina become unavailable.
You make a point of saying to whom it is disclosed. What would be the limitations you would apply?
Your Honor, I think as a starting point, the Shield statute is broadly written. It applies to any person, to any agency or department of the state. That's a policy decision the General Assembly has made, and it's sovereign prerogative.
No, I gather what I'm getting at. You're saying that the limitation on disclosure, there should be some, and I'm asking you, where should that limitation be?
And as my starting point, Mr. Chief Justice, is the language of the Shield statute. I think if something is protected by the Shield statute, it is prohibited from any disclosure whatsoever.
And if we assume we disagree with you,
I suspected that was the follow-up, Chief, Mr. Chief Justice. If the court thinks something's got to be disclosed to someone, Section 24.3.530B, the director's certification of the available methods, is the logical place to require information to be disclosed. I would think depending on what information the court would require to be in there, that could well be in an ex parte in-camera order for the court's review only to protect its disclosure even further beyond the court's chambers itself. And if the court's going to go much more than that, whatever's disclosed needs to ensure it complies with the plain text and the intent of the Shield statute.
Well,
And
let me ask you a question about that. So under sections A and B of 530, I think that you would agree, taking the question of disclosure and removing it for this purpose, but these two subsections impose on the director the responsibility of conducting a reasonably thorough search to find the drugs that would be used for a execution.
Yes, Justice Few, I agree with
Okay.
that. Last time, I'd still agree with it.
All right. And we talked about it last time in the context of the drugs being unavailable. And in order for someone to understand whether the director conducted a reasonably thorough search, it would be helpful, at least, for the director to explain in some general sense, at least, what the director did to try to find the drugs. All right. So here now, we're talking about this in the context of the drugs being, yes, available. And so that raises going back to the subsection A, lethal injection is one of the options if it is available. So to me, the same notion applies to the word "it" there, that the director must make a reasonable, thorough inquiry, even if it's completely internal, that it is the right thing, and not just accept the word from somebody else who isn't reliable. You would have to agree with that, I suppose.
I certainly, and with
Right.
the caveat that I want to make sure the director, who is not a pharmacist in any sense, can discuss with the experts at SCDC to make that certification, certainly. But I don't think he's got to do the testing or any inquiry himself if he doesn't have the scope of that knowledge. As long as we're on the same page there, yes,
Okay.
I agree with you.
So you also will recall that last time I brought up this idea of a determination coming from the, you know, my old work on the procurement code case.
I remember it well.
And, but to me, it does seem applicable that when the statute gives the director the responsibility of, one, making reasonable efforts to obtain it, and then upon the obtaining of it, to make a reasonable inquiry into whether it is what it is supposed to be, that it makes sense, following up on that statutory requirement, that the director gives some explanation of what he's done. Now, when doing that, as you have pointed out, the director is required to comply with the SHIELD statute, is forbidden, I suppose, from revealing information that would violate the SHIELD statute. So why would it not be incumbent upon the director, considering all of those prohibitions, all of those responsibilities, to simply make a written statement that says something along the lines of, we have obtained phenobarbital to carry out this execution, and the way we know it is what it is blank, and fill in the blank. Whatever that blank is, then once that statement is, it might be we've got it from a reliable supplier. It might be it complied with all government regulations when we obtained it. It might be that we tested it at SLED. It might be that it was independent testing. Whatever it was, revealing no information that violates the SHIELD statute or otherwise compromises the director's ability to obtain these drugs in the future, simply explaining how he knows that it's phenobarbital. Mr. Bloom receives that. If he's satisfied with it, no issue. If he's dissatisfied with it, he makes a motion in the court, and the court determines at that point in time whether or not the disclosure is sufficient. What's wrong with that?
There's a lot there to unpack. I want to try and take pieces of it to make sure I respond to it as holistically as possible. One, I appreciate that your question doesn't limit the director to one particular or two particular ways of confirming what the drugs are and making that determination that it's available, that it leaves it to his discretion to make that certification. Second, if the court thinks that if it is available requires such a determination, I think that, let me step back, Justice Few. Yes, the director has to determine it is available. That includes not only saying, well, here's a bottle on the shelf, but knowing what the bottle is. If the court interprets subsection A as somehow requiring the director to inform this court of how he reached that conclusion, I would encourage the court to make clear exactly what it expects the director to provide, so that when the director files his certification under subsection B, we're not going back and forth with, we want to know more, we want to know not. This court's in re stays order probably provides a template with which that could be done. And my third point, Justice Few, would be this. I suspect that most inmates, upon receipt of the certification, will be in this court saying, we're not happy with something. So
And we can rule on that.
the court certainly can. but
And
I
we can
just-
rule on it in 2 hours if we have to.
I don't disagree with that. I just make the point that I suspect.
And what I'm trying to suggest to you and to advocate here is that this court would not say what the director has to disclose. The director makes that decision about what to disclose. And then the courts in due course will determine whether that disclosure is sufficient under law.
If that's the way the court wants to have these proceed, Justice Few, that's the court's prerogative to do so. I would just urge the court not to adopt any sort of procedure that results in more of a ping pong back and forth and more of what, again, Justice Alito called the seemingly endless proceedings, that it be done in a way that brings these to a swift conclusion so that a notice of execution wouldn't expire while the dispute was still going back and forth in court or whether the drugs were sufficient. If there are no further questions, Mr. Chief Justice, thank you.
Thank you both for your arguments today. They were enlightening, answered some of our questions. I'm certain we left you with some questions as well. We are now in recess.
Are we gonna come right back and do the argument, the cross argument? There's supposed to be another argument. So we did it all at once.
Did it all at once. Yeah.
penalty. That gave their Supreme Court pretty clear signal, and they
Of the quality control and the testing for potency, purity, and stability.
Subsection A,
the denial has occurred. Assume that a trial judge stated, I've got a compelling reason for invading the